You found the podcast, Go Beyond the Brief, where we take a deep dive into the societal currents shaping our lives. Together, we'll explore the often unseen forces at play. We'll examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society,
for a year,
this is the
facing
place.
thousands of dollars in fines and carrying a permanent criminal record, all because you kept a secret.
Right.
But not just any secret, right? A secret you were legally bound by a priest's collar to keep.
Yeah, an absolute vow.
Or, on the flip side, imagine facing that exact same jail time because you were just fixing a neighbor's crashed hard drive in your basement. You stumbled across a questionable file, and you decided to just look the other way. Welcome to the deep dive.
It is a wild reality to consider.
It really is. You know, we often think of law enforcement as something strictly reserved for the police or, maybe specialized government agencies. But what if the government is quietly deputizing you?
Deputizing everyday people.
Exactly. So today, our mission is to explore the rapidly expanding, highly controversial, and honestly legally perilous world of mandated reporters.
Which is a huge topic.
It is. These are everyday citizens who are legally obligated under threat of prosecution to report suspected child abuse or neglect to the authorities. And we have a massive stack of sources to guide us through this today.
We really do.
We are looking at California's Assembly Bill 653, which targets Hollywood. We've got Connecticut Senate Bill 157, which completely overhauls municipal summer camps.
Yep.
Plus, a massive U.S. Department of Justice complaint against Washington state, and some excerpts from the Vermont House Journal regarding House Bill 880.
And, while those might sound like four completely disjointed pieces of legislation from like four different corners of the country, they actually represent a unified, sweeping trend.
Okay, let's unpack this. Because while mandated reporting sounds like bureaucratic paperwork, it's actually the center of this massive collision right now.
Well, absolutely.
Yeah.
The state is fundamentally rewriting the social contract. In its urgent and entirely understandable drive to protect vulnerable children from abuse, the government is just casting an incredibly wide net.
Yeah.
But as we're going to see today, when you cast a net that wide, you don't just catch predators. You catch IT professionals, film developers, camp counselors.
Hidden priests.
Exactly. You even end up on a direct collision course with ancient religious vows and the First Amendment of the Constitution.
So I want you to imagine you're just doing some HR paperwork or fixing a network server, and suddenly you realize you are legally bound to report a suspected crime.
Under threat of literal jail time.
Right. So we need to start by understanding how big this umbrella of mandated reporters has actually gotten. If you were to ask someone on the street to name a mandated reporter, they would almost certainly say a kindergarten teacher.
Or a pediatrician.
Yeah, or a social worker. And historically, that was the boundary. The law applied to people whose entire profession centered on the continuous direct care of vulnerable populations.
Like the traditional view.
But looking at our sources from Connecticut and California, that traditional view is completely obsolete. The line between civilian and state informant is just gone.
It is entirely gone. To understand how the burden of liability is shifting, let's look at Connecticut first.
Okay.
So Senate Bill 157 is ostensibly about municipal camp safety. Now, municipal camps are those local, town-run summer programs.
It's like the local parks and rec stuff.
Exactly. They aren't massive private sleepaway camps. They're the programs where parents send their kids for a few weeks in July. And this bill explicitly adds paid youth camp directors, assistant directors, and staff members who are 21 years of age or older to the mandated reporter list.
Wait, so you're telling me you are a 21-year-old college kid home for the summer.
Right.
You take a minimum wage job handing out basketballs and juice boxes at the local rec center, and suddenly you carry the exact same legal reporting liability as a licensed pediatric psychiatrist.
That is the practical reality.
Yeah.
And the state is not just handing out this title and walking away. They're enforcing a massive compliance structure around it.
Which is where that audit comes in, right?
Right. The bill demands a highly detailed report by January 1st, 2027 from the Office of Early Childhood.
And this isn't just a casual survey.
No, not at all. Connecticut wants to audit exactly what is happening in every single municipal youth camp across the state to see if they are upholding these safety and reporting standards.
I want to break down what that 2027 audit actually entails, because it shows how hyper-focused the state has become on this. The Office of Early Childhood has to evaluate whether these local camps require employees to have emergency first aid or CPR training.
which makes sense on the surface.
Right, but they're also checking if camps authorize employees to administer medication to kids.
Which is a huge liability in itself.
Exactly. And they want to know if there are written, codified policies on hiring and facility safety. And critically, they are auditing whether these camps conduct comprehensive criminal background checks on prospective and current employees.
And that level of scrutiny just changes the entire ecosystem of a summer camp. I mean, they are collecting data on the number of children served, their age ranges, and the operating schedules. It is. The state is essentially saying that when you take custody of a child, even for a 3-hour afternoon arts and crafts session, you are operating a regulated facility.
And that 21-year-old staff member is now the eyes and ears of the state child welfare system.
Yes, exactly. If that college student notices a kid comes to camp with unexplained bruising, or the child makes a concerning comment about their home life, that counselor cannot just tell their boss and assume it's handled.
Oh, wow.
They are personally, legally mandated to ensure the state is notified.
I know you're probably thinking, well, okay, that makes sense for a camp counselor. They are actually watching kids. But if Connecticut is turning summer camps into highly regulated compliance zones, California is taking that compliance model and applying it to, like, your local strip mall.
Yeah, California's a whole different ballgame.
I want to look at California Penal Code 11165.7. It is just a staggering piece of legislation. There are 50 different categories of mandated reporters on this list. 50. And this is where we really have to answer the question of who is actually covered by these new reporting laws. We've got the usual suspects, teachers, firefighters, doctors.
Sure.
But then you read further down, and it feels like a corporate compliance audit applied to everyday citizenship. Listen to this specific entry: a commercial film and photographic print or image processor.
We really need to unpack the mechanics of that specific definition. Because when we hear film processor, we might picture someone in a dark room developing Kodak film in the 1990s.
Right, like a retro photo lab.
Exactly. But the statute is aggressively modernized. It explicitly states that this category includes anyone who prepares, publishes, produces, develops, duplicates, or prints any representation of information, data, or an image.
Yeah, it specifically lists CD-ROMs, digital data, videotapes, computer floppy disks, and computer-generated equipment. So if you just work at a local print shop printing out a banner for a family reunion, or maybe you have a side gig transferring people's old VHS home movies to digital MP4 files for a fee, California has deputized you as a mandated reporter.
And they go even further into the tech world. The list includes a commercial computer technician.
Oh, this one is wild.
It is. The law defines this as any person who repairs, installs, or services a computer, including memory storage, recording mechanisms, or networks, for a fee.
So imagine you run a small IT repair shop. A client brings in a water-damaged laptop. Your job is just to recover the hard drive.
A super standard job.
Right. But while you are transferring the data, you see a thumbnail image that looks incredibly concerning, potentially illegal, involving a minor.
Yeah.
The state of California is basically saying if you see it, you legally own it. You can't just delete it, and you can't just hand the laptop back and say you don't want to get involved. You must report it to law enforcement.
You have no choice.
And it also includes animal control officers, humane society officers, and get this, human resource employees of businesses that employ minors.
That's a big one.
Yeah. If an HR employee is designated to accept complaints of misconduct in a corporate office, they are a mandated reporter.
The underlying logic here is a radical expansion of the state's surveillance apparatus, using civilian professions as the nodes. I mean, the legislature has realized that child abusers don't always operate in front of teachers and doctors.
They hide it.
Exactly. Abuse is often hidden, and the people most likely to accidentally uncover it are the people interacting with a suspect's private data, their home networks, their pets, or their employment records.
But I have to push back here, because this sounds incredibly fraught. Does casting the net this wide actually protect kids? Or does it just create a mountain of false alarms?
That's the big debate.
Right, because if I'm an IT guy fixing a server and I see something that might be sketchy but I have zero context for it, I'm going to report it just to save my own skin, right?
Yeah.
Doesn't this just flood Child Protective Services with garbage data because everyday people are terrified of the penalties?
That is the central critique of these sweeping laws. It creates a phenomenon in the system known as CYA. Cover your assets. When you attach severe criminal penalties to a failure to report, human nature dictates that people will over-report. They will report vague suspicions, out-of-context photos, or odd behaviors just to ensure they aren't prosecuted later.
Which makes sense from a self-preservation standpoint.
Totally. But then child welfare agencies can become overwhelmed with investigating innocent parents or harmless situations, which drains resources away from the kids who are in actual immediate danger.
And we really have to talk about those penalties to understand why people are so terrified. Let's identify the exact penalties in California for failing to report known or reasonably suspected child abuse or neglect.
Let's do it.
It is classified as a misdemeanor. If you fail to report, you face up to 6 months of confinement in a county jail, a fine of $1,000, or both the imprisonment and the fine.
So real consequences.
Yeah, 6 months of your life gone and a criminal record just because you didn't call the police over a file you saw while fixing a motherboard.
And we should clarify that the legal standard is known or reasonably suspected. You don't need absolute proof.
Right, you don't have to be a detective.
Exactly. If a reasonable person in your professional position would suspect abuse based on what you saw, the legal obligation is triggered. Now, the law does strongly encourage employers to provide training on how to identify abuse, but there's a brutal legal catch here.
Uh-oh.
The absence of training does not excuse a mandated reporter from their duties.
So you can't stand in front of a judge and say, Your Honor, nobody ever trained me on what child abuse looks like in a digital photograph.
Exactly. Ignorance of your legal status or ignorance of the indicators of abuse is not a valid legal defense in California. The state presumes you know your duty.
Which is honestly terrifying. And that brings us to the specific California source we are examining today, which adds yet another group to this massive 50-item list. We are looking at Assembly Bill 653, which created the Camera Act.
Yes, the Child Abuse Mandated Entertainment Reporter Act. This targets a very specific ecosystem, which is the entertainment industry.
We need to answer a specific question here, which is, why did the legislature create the Camera Act? Because when you think about a movie set, it seems like there are already 1 million people around.
It's very crowded.
Right. But our sources detail that this act was created to impose reporting requirements on a, quote, new class of persons who provide services to minors in the entertainment industry. Specifically, it targets individuals employed as a talent agent, a talent manager, or a talent coach.
To understand the why behind this, we have to look at the power dynamics and the geography of how a child actor actually works. You are right that a union film set is highly regulated.
Lots of rules.
Yeah, there are directors, camera operators, union representatives, and mandated studio teachers. A child actor on a soundstage is highly visible. But the legislature realized that the most dangerous interactions don't happen under the bright lights of a soundstage. They happen in the hidden, preliminary stages of the industry.
Right, like just getting the job in the first place.
Exactly. Talent agents, managers, and acting coaches operate in a unique, heavily isolated capacity with minors. Consider an acting coach. They aren't working on a crowded set. They're often holding private one-on-one coaching sessions in a rented studio or even in their own living room.
Wow, yeah.
And a talent manager might be traveling alone with a child to auditions or having private meetings to discuss career strategy.
And these people hold immense, almost absolute power over that child's future. I mean, if a manager is the gatekeeper to a kid becoming a star, that is a dynamic incredibly ripe for abuse.
Highly susceptible.
Or, perhaps even more insidiously, it's a dynamic where a manager might realize a powerful producer is acting inappropriately with their child client, but the manager just looks the other way just to keep the paychecks flowing and the movie deals intact.
And that is the exact loophole the legislature wanted to close. By forcing agents, managers, and coaches to become mandated reporters, California is fundamentally rewiring the Hollywood machine.
It's a huge shift.
It is. An acting coach is no longer just a career advisor giving tips on reading a script. They are now legally mandated guardians of that child's welfare. If a talent agent knows or reasonably suspects that a child star is being abused by a director, and that agent stays quiet to protect a multi-million-dollar franchise deal, that agent is now risking their own personal freedom.
They're on the hook?
Yes, they're risking 6 months in a county jail.
It basically takes the industry concept of protecting the talent and weaponizes it into a literal legal mandate. It's a fascinating shift in accountability.
Completely changes the incentives.
But as we've seen, the state is incredibly comfortable wrapping its arms around Hollywood agents, IT repair guys, and camp counselors. But what happens when the state's mandate crashes directly into the First Amendment of the U.S. Constitution?
Well, this is where the legal landscape transforms from a debate about industry regulations into a profound constitutional crisis. We are moving our focus from California to Washington state, We are examining a U.S. Department of Justice complaint in intervention against a Washington law, Senate Bill 5375, which was signed by Governor Bob Ferguson.
Just the phrase DOJ complaint in intervention tells you how serious this is.
It's huge.
The federal government is stepping in to fight a state law. So what did Washington state do? SB 4375 explicitly adds any member of the clergy to the mandatory reporter list.
Yep.
If a priest, pastor, or rabbi suspects child abuse or neglect, they are legally mandated to report it to the authorities within 48 hours, like at the very first opportunity. And they have to provide the identity of the accused if they know it.
And we must identify the penalties in Washington state because they are significantly harsher than what we saw in California.
Much harsher.
In Washington, the failure of a mandated reporter to notify authorities is classified as a gross misdemeanor. That is punishable by up to 364 days in county jail, a fine of up to $5,000, or both. Plus, they can be held entirely responsible for civil liability.
I really want to explain civil liability for a second because that's the financial ruin part of this. That means if a child is abused further because you didn't report it, the victim's family can sue you personally in civil court for damages.
Exactly.
You could lose your house, your savings, literally everything, on top of spending nearly a year in jail.
Precisely. It is a dual-pronged threat of criminal incarceration and absolute financial devastation.
But applying these threats to the clergy triggers a massive theological crisis. The DOJ complaint centers heavily on the Catholic sacrament of penance and reconciliation, which most of us just know as confession.
Right.
Now, whether you are religious or not, it is vital to understand that this isn't just a casual counseling chat with a pastor in a church office. This is one of the 7 holy sacraments of the Catholic Church.
The DOJ complaint does an excellent job outlining the historical and theological weight of this. Confession has been part of Catholicism since its earliest origins, rooted in Scripture. The penitent confesses their sins aloud to a priest in order to ask God for forgiveness, and the priest, acting in the person of Christ, provides absolution.
Right.
But the absolute lifeblood, the entire foundational requirement of this sacrament, is the seal of confidentiality.
Yes, the source actually cites the specific internal law of the Church, Canon Law 983, Section 1. I want to read the exact phrasing because it is uncompromising.
It leaves no room for debate.
It really doesn't. It says, quote, "The sacramental seal is inviolable. Therefore, it is absolutely forbidden for a confessor to betray in any way a penitent in words or in any manner and for any reason."
For any reason.
Right. It doesn't say unless it's a really bad crime. It says for any reason. Priests are entirely prohibited from using any knowledge acquired from confession to the detriment of the penitent, even if all danger of revealing the person's identity is excluded.
And the religious penalty for a priest who breaks that seal is the ultimate punishment that exists within the Church. If a priest breaks the seal, they incur what is called an automatic laete sententiae excommunication, which is reserved directly to the Apostolic See, meaning the Pope.
Let's break down latte sententiae in practical terms, because this isn't like getting fired from a job where you have a meeting with HR and a performance review.
Not at all.
It translates to sentence already passed. It is an automatic spiritual exile. The very second the priest speaks the secret to the police, the excommunication happens instantly.
There's no delay.
There is no church trial. There is no appeals process. They're immediately removed from the church. They cannot receive the sacraments. They cannot act as a priest. Their entire spiritual and community life is severed.
So Washington State has engineered an impossible dystopian dilemma for Catholic priests. To comply with the state law, SB 5375, and avoid up to 364 days in a state jail and $5,000 in fines, a priest must disclose information obtained solely through a sacred religious rite. But doing so places them fundamentally at odds with their core, deeply held beliefs and guarantees their immediate ecclesiastical exile. They had to choose between a physical prison cell or spiritual destruction.
And I want to pause here and issue a very clear point of context for you, the listener. We are discussing highly charged political, legal, and religious issues. We are not taking sides here.
Absolutely not.
Our goal is to impartially report on the conflict between the state's intent to protect children and the DOJ's argument that this law infringes on constitutional religious freedoms. We are just looking at the mechanics of this collision.
And the mechanics of this collision become incredibly complex when we look at how the law defines what actually needs to be reported. We tend to instinctively focus on the most extreme, horrific cases of intentional physical abuse.
Right. The worst case scenarios.
Yes. But the Washington law mandates reporting for abuse and neglect.
Here's where it gets really interesting and honestly a bit terrifying for anyone seeking help. The DOJ complaint highlights that under Washington law, neglect includes negligent treatment. And the state defines negligent treatment as a failure to act that constitutes a clear and present danger to a child's health, welfare, or safety.
It's an extremely wide net.
That is an incredibly broad legal net. It's not just about intentional harm. It's about a lack of resources or a failure of supervision.
The distinction between intentional abuse and neglect is critical here. Abuse is an action taken against a child. Neglect, particularly negligent treatment, is often a byproduct of circumstance, poverty, or systemic failure.
Right. So I want you to imagine a scenario. A struggling, impoverished parent walks into a Catholic church and goes into the confessional booth. They are weeping. They confess to the priest that they have fallen so far behind on rent and bills that they haven't been able to afford adequate food for their kids for the last 3 days.
Heartbreaking.
Or they confess that they had to leave their 4-year-old toddler home alone for a few hours because if they missed their shift at work, they would be fired and they couldn't afford childcare. They are just seeking spiritual comfort and community help. But under this Washington law, that priest is legally bound to report that struggling parent to state authorities for negligent treatment within 48 hours.
And we have to follow that action to its logical conclusion. When a mandated reporter calls the state hotline for neglect, it almost certainly triggers a child welfare investigation.
Which is a massive escalation.
Right. Social workers and police arrive at the home. Depending on the severity of the food shortage or the lack of supervision, this can easily escalate into a dependency action.
Let's define dependency action for the listener. That is the formal legal process where the state steps in, declares that the parents are unfit or unable to care for the child, and physically removes the children from the home, placing them into the foster care system.
Yes. So the DOJ is arguing that the state's law creates a massive, devastating, chilling effect on religious practice. The priest is terrified of going to jail for a year. The penitent is terrified of having their children taken away by the state.
Yeah.
And suddenly the confessional booth, which for centuries has been designed as the ultimate impenetrable safe sanctuary for a broken soul to seek help, redemption, and guidance, is effectively bugged by the state.
Wow. Bugged by the state.
People will simply stop confessing. They will stop seeking help from their religious leaders out of fear of state retribution.
But let's look at the other side of the coin, because the state of Washington has a very powerful counterargument. Senator Noel Frame, who introduced the bill, argued passionately that the legislature has a paramount overriding duty to end cycles of abuse.
The primary duty of the state.
The state's argument is that a child's physical safety in the real world trumps any spiritual or religious privilege. When a child asks for help, or when an abuser confesses to harming a child, the state is saying, we cannot have a loophole where abusers confess their crimes, get absolved, and walk away consequence-free, leaving kids in perpetual danger.
The state's position is that a child cannot protect themselves, so the government must compel adults to do it, regardless of their religious vows.
Yeah.
And it is very important to note, based on the DOJ complaint, that the Catholic Church is not arguing that priests shouldn't be mandated reporters at all.
That's right.
Outside of the confessional booth, priests are already mandatory reporters.
Yes, that is a crucial distinction. The DOJ points out that Catholic priests undergo extensive training to identify and report abuse. The complaint even includes testimony from Bishop Frank Schuster of the Seattle Archdiocese.
Oh, right, the bishop's testimony.
Yeah, he testified about a real situation where a minor came to him for counseling outside of a formal confession regarding an inappropriate relationship with an adult. Because it wasn't under the sacramental seal, the bishop immediately called the police and the boy's parents.
He took immediate action.
The church also operates under the Dallas Charter, which explicitly mandates that priests must report allegations of abuse to civil authorities. The sole singular exception they are fighting for is when that information is obtained strictly through the sacrament of confession.
So the DOJ is not arguing against mandated reporting as a concept. They are arguing that forcefully piercing the specific sacramental seal of confession is an unconstitutional infringement on the free exercise of religion guaranteed by the First Amendment.
Right.
But the DOJ doesn't just rely on a broad philosophical argument about religious freedom. They bring a very sharp, very specific constitutional argument to the federal court based on the 14th Amendment and equal protection. They are arguing that Washington state is engaging in blatant legal hypocrisy.
Okay, let's get into this courtroom battle, because this is where the legal chess match gets fascinating. Washington state explicitly stripped the clergy of the right to use the confessional privilege as a defense for not reporting abuse.
We took it away.
But the DOJ points out a glaring issue with how the state handled a completely different group of professionals just days earlier.
The timing of the legislation is what makes the DOJ's case so compelling. Just 3 days before Governor Ferguson signed SB 5375, which criminalized the silence of priests, he signed another bill into law, substitute House Bill 1171 or SHB 1171.
And what did SHB 1171 do? It restored the attorney-client privilege for university lawyers. Here's what happened. Law professors, clinical instructors, and in-house counsel working at state universities were accidentally caught up in the mandated reporter net simply because they were technically classified as higher education employees.
Right, a technicality.
This meant they were suddenly being legally forced to report things their clients were telling them in strict legal confidence. The state legislature saw this, realized it destroyed the concept of attorney-client privilege, and swiftly passed SHB 114071 to carve out an exemption for them.
And we really need to look closely at the standard the state set for those lawyers. Under SHB 1171, a university attorney only has to break privilege and report something if it is necessary to prevent reasonably certain death or substantial bodily harm.
Let's explain what that threshold, reasonably certain death or substantial bodily harm, actually means in practice, because it is entirely different from the standard applied to everyone else.
It's a completely different bar.
If a client tells a lawyer, "I have been hitting my child," that is a past crime. The lawyer does not have to report it. Their lips are sealed. But if the client says, "I'm going to go home right now and murder someone," that triggers the reasonably certain death exception, and the lawyer can call the police. So attorneys are protected from reporting past abuse or ongoing neglect. Keep that incredibly protective standard in mind.
Now, during the legislative debate over the clergy bill just a few days later, Senator Leonard Christian proposed an amendment for the priests. He proposed giving the clergy the exact same exception they had just handed to the lawyers.
Make it equal.
Right. He suggested that a priest should only be forced to break the seal of confession to prevent reasonably certain death or substantial bodily harm.
And then the legislature voted it down. They explicitly rejected it. They protected the lawyer's secrets, but they decided to criminalize the priest's secrets.
This is the absolute crux of the DOJ's 14th Amendment equal protection argument. The Equal Protection Clause of the Constitution prohibits states from making classifications that invade fundamental rights unless those laws are narrowly tailored to achieve a compelling government interest. Under the Constitution, religion is considered a suspect class.
Meaning the government cannot treat religious groups worse than secular groups without an incredibly undeniably good reason. You can't write laws that specifically target religion while letting secular equivalents off the hook.
Precisely. The DOJ is arguing that Washington state is deliberately targeting a suspect class. You cannot strip a sacred, constitutionally protected religious privilege from priests, threatening them with jail time, while simultaneously passing laws to protect a secular legal privilege for attorneys.
I really want to illustrate this for you, the listener, because it is wild when you put these two scenarios side by side in the real world.
The contrast is stark.
Imagine a clinical law instructor sitting in their office at a state university. A client comes in, closes the door, and confesses that they have been severely neglecting their child, maybe locking them in a room for days without food.
Awful.
Because of SHB 1151, that lawyer is shielded by state law. They do not have to report it. Their lips are legally sealed by secular attorney-client privilege. Now imagine that exact same client leaves the lawyer's office, walks 2 blocks down the street, enters a Catholic church, steps into the confessional booth, and confesses the exact same crime of neglect to a priest. Under SB 5375, if that priest keeps his religious vow of silence, he commits a gross misdemeanor, faces 364 days in jail, and a $5,000 fine.
It is the identical confession concerning the identical child, representing the identical danger. Yet the secular lawyer is granted absolute immunity, and the religious priest is handed a year in prison.
Yeah.
That stark discrepancy is the equal protection argument the DOJ is taking to federal court. They are seeking an injunction to stop Washington from enforcing this law against the clergy, arguing that it is fundamentally unconstitutional discrimination.
And this legal collision is not just some isolated, quirky issue happening in the Pacific Northwest. If we look at our final source, the excerpts from the Vermont House Journal, we can see that this is a national ripple effect.
Let's move over to the East Coast to see how this trend is spreading. We're looking at Vermont House Bill H-880, which was introduced by Representatives Cole, Greer, and a dozen other lawmakers. The title of the bill alone tells you everything you need to know about the legislative intent. It is literally titled, An Act Relating to Repealing the Exception for Clergy to Report Child Abuse and Neglect.
It was referred to the Committee on Judiciary. It is short, to the point, and it mirrors exactly what Washington state is attempting to do. It shows that the tension between closing abuse loopholes to protect children on one side and protecting First Amendment religious liberties on the other is becoming a nationwide legislative battleground.
State after state is opening up their mandated reporter laws, looking at the historical exemptions carved out for the clergy, and deciding that the potential risk to children outweighs the constitutional protection of religious privilege. They are systematically trying to close what they view as dangerous loopholes.
Which means we are going to see more lawsuits from the Department of Justice, more constitutional challenges making their way to the Supreme Court, and more everyday professionals, along with priests, caught in the brutal crossfire between state child welfare laws and federal constitutional rights.
We are witnessing a profound shift in how the state views its citizens. The state is essentially declaring that when it comes to the welfare of a child, there is no such thing as a private conversation. And there is no such thing as an innocent bystander.
Right.
Whether you are a Hollywood talent agent negotiating a contract, a computer repair tech recovering a hard drive, a 21-year-old handing out snacks at a summer camp, or a priest sitting in a dark confessional booth, the state is conscripting you into its surveillance network.
We have covered a massive amount of ground today on a really heavy topic. We've traced the incredible, unprecedented expansion of mandated reporters. We started by looking at how Connecticut's Senate Bill 157 is pushing to audit municipal summer camps, demanding reports on CPR, medications, and background checks, placing immense legal weight on 21-year-old staff members.
And we looked at California's staggering 50-item list in Penal Code 11165.7, sweeping up commercial film processors, computer techs, and HR reps.
And we answered our core focus regarding the entertainment industry, summarizing exactly why the California legislature created the Camera Act.
Right. They specifically targeted talent agents, managers, and coaches to close a dangerous loophole, recognizing the immense power and highly isolated environments these individuals control over child actors.
We also detailed the severe penalties involved for anyone who fails to report known or suspected abuse. In California, it's a misdemeanor carrying up to 6 months in jail and a $1,000 fine. And in Washington state, it escalates to a gross misdemeanor, carrying up to 364 days in jail, a $5,000 fine, and the very real threat of civil liability that could wipe out your life savings.
Finally, we explore the dramatic DOJ lawsuit in Washington over the Catholic seal of confession, highlighting the agonizing tension between state child safety mandates and ancient, unbreakable religious vows. We broke down the 14th Amendment hypocrisy of the state protecting an attorney loophole while simultaneously criminalizing the silence of the clergy, a battle that is now spreading to states like Vermont.
It all paints a picture of a society where the eyes of the state are expanding rapidly into every corner of our private lives and professions. And whether you are a parent dropping a kid off at a municipal camp, an IT tech fixing a server for a local business, a manager in Hollywood, or just someone sitting in a church pew on a Sunday morning, you need to be acutely aware of this shifting landscape. The legal responsibilities placed on the shoulders of everyday citizens are heavier, more complex, and more strictly enforced than they have ever been in history. And as we learned, ignorance of the law is never an excuse.
The immense burden of protecting society's most vulnerable is no longer just the job of the police or child protective services. It is being distributed across the entire civilian workforce.
So, what does this all mean for the future? We want to leave you with this final provocative thought to mull over. We've seen states argue passionately and compellingly that they have the right to pierce the absolute sacred seal of religious confession in the name of child safety. But if they win that constitutional argument, what happens next?
That is the ultimate question of precedent. In law, once a door is forced open, it is rarely closed again.
Exactly. If the state successfully establishes that it can break a religious seal for suspected child abuse, could the government eventually demand that priests reveal confessions related to other crimes? What if the state decides it needs to stop financial fraud or corporate theft or domestic terrorism? Once the state decides that secular law supersedes sacred vows for one specific crime, where is the permanent, immovable line drawn between state security and absolute religious confidentiality? Does the sanctuary of the confessional eventually just become another arm of state surveillance? Something to think about the next time you drop off your laptop for repairs or step into a church. Thank you for joining us on this deep dive. We'll catch you next time.